So first, thank you very much for having me. I was struck this morning by one of Alta's slides where on the Sunday Riley stimulant. So I'm offering myself as a Monday Riley stimulant and hoping I'm a little more effective. The U.S. Doing this in 15 minutes is actually giving you an entire class on FDA law, which I'm going to resist doing. But what I do want to emphasize at the very beginning is, first of all, my answers to Ellen are essentially what you heard lawyers do earlier this morning: yes and no, maybe. I'm not going to be able to give you very concrete answers. I never can, but this is an area where I really can't. I actually, never mind do I not know where FDA law is going, I no longer know where law is going. So this is an area, unfortunately for us, that tracks many of the fault lines in jurisprudence right now, and that is going to complicate things as we go forward. I think the first thing to start with is, especially in a room that is still, I think, more scientists than lawyers, which is to say, if you were doing this from scratch, you would never do it the way we've done it. We are constrained by statutes that were passed in 1902 and 1938. They have been amended a fair amount since then. But the basic structure is based on those two statutes, and that constrains what we can do with it. And these statutes are actually remarkably ill-fit to stem cell technology. And so that is a difficulty we're going to have to work with. So I'm going to start with FDA regulation, just based even on our discussion so far. FDA regulation is the big brother in the background. Ellen mentioned products. If you're talking about products, you are actually talking about, in FDA lingo, products or articles in interstate commerce. Although that's a little bit complicated because we're also dealing with the first statute, which is the 1902 statute, which does not have necessarily an interstate commerce piece, but a piece that is tangled with contagion and infection and other pieces that are still not clear. So it's worth also seeing how this originates. FDA claimed authority to regulate cell technologies really since the 70s, but it did not move to actually regulate them until the 90s. And it's worth seeing what was going on at that time. You actually have, on one hand, IVF burgeoning in clinics and burgeoning in a context that was largely unregulated and to this day is still largely unregulated. And many of the stem cell clinics that you see will actually say, well, we're just like IVF. The other piece is surgeons who were dealing with transplantable tissues, largely unregulated because these were not viewed as products. This was the treatment of medicine. And it's not accidental that a lot of these clinics are actually run by surgeons. The last piece was gene therapy, which actually very quickly was highly regulated with oversight from both the RAC, NIH, FDA, crossing into many different places. And originally these were on two different tracks, ultimately consolidated in the 90s by FDA. And so what you got with FDA in its regulations that came out in the late 90s, finalized in 2004, was that we would have a tiered risk-based approach that would apply to all human cellular and tissue-based products. So all of these tissue and cell-based products are subject to registration and good practice requirements. And that would apply to the clinics as well that argue that they are not subject to further regulation. They still are subject to this much regulation. And this is under Section 361 of the Public Health Service Act, which again, as I said, is the older statute. We're still not quite sure of the full parameters of it. And Alta mentioned this phrase, which is the key phrase actually to the next step, and that is minimally manipulated. Minimally manipulated is not in the statute. It's nowhere in the statute. It does appear in the regulations. One can argue, and FDA certainly has, but it has not been without controversy, that minimally manipulated flows directly from the language of the statute, and we should therefore use it in that context. We still don't have a full definition of minimally manipulated. And when the regulations were first proposed in the late 90s, the idea was actually that originally very little was going to be minimally, more than minimally manipulated. That's a tongue twister. But what you would actually get is, as we got more experience with these different technologies, we would decide that more and more of them would fit under the lower tier rubric than the upper tier rubric. That has actually not happened. There was an initial movement of one place with expansion moving down into the minimally manipulated, but since then FDA has not expanded the minimally manipulated approval pathway. So another piece to have is that FDA, because it knows it's complicated, has established what's called this tissue reference group to determine the applicability of whether it's minimally manipulated or more than minimally manipulated. If you actually look at the tissue reference group decisions, and certainly the clinics howl about this, you will actually see it's hard to actually figure out exactly what's going on. Part of that's that we don't actually have the full data, and that's part of the FDA process. You don't always get the full data. A lot of this is trade secrets that may not be available to everyone. One of the things Ellen asked was, what are the pathways to get this outside of a clinical trial? The typical pathways that FDA uses for expanded access came largely out of the AIDS movement. And so expanded access tends to start with phase 2 or phase 3, far beyond the typical pathway that many of the clinics are talking about, which would have us move essentially at a stage that's largely a phase 1 stage. Another test of this that Alta's mentioned a couple times is the case of the Abigail Alliance. In Abigail Alliance, the attempt on libertarian standpoint was if you have a terminal disease, you should have access to drugs. Actually, in that case, they did not ask for that much. It was at a phase 2 and beyond stage. That case actually does play an important role in stem cells because the D.C. Circuit en banc said, no, you don't have that as a separate liberty right. And it actually ties in with where we're going as I move on. So, challenges to FDA regulation. FDA has sent warning letters to many, many of the clinics that are offering these types of stem cell therapies. And one is Regenerative Sciences, which is based in Colorado. It is a product, just as Ellen said. It manufactures, I guess theoretically, a product called Regenerative. The key factor with Regenerative, it is actually adult mesenchymal stem cells. They are autologous, but they are taken out of the body, mixed with other factors in the body for expansion, and crucially for those of us who teach FDA law, mixed with doxycycline, which actually, I skipped one step. If it's more than minimally manipulated, you are then subject not just to the Public Health Service Act, but you are subject to the Food, Drug, and Cosmetic Act, and as well as the PHSA, as a biologic drug or device. And that actually subjects you to the whole regulatory pathway, phase 1, 2, 3, that is required for those types of, well, for drugs. In this case, remember, Food, Drug, and Cosmetic Act is predicated on interstate commerce. It's actually the only piece that is in interstate commerce here is probably the doxycycline. It requires us to actually look, and I don't know how many of you got into the weeds of the Obamacare case, but the Obamacare case case was decided in the Commerce Clause piece on the idea that if something substantially affects interstate commerce, it is then going to be viewed as a product subject to regulation. The bad news is 5 out of 9 justices said no on that standard of substantially affecting interstate commerce in the narrow case of Obamacare, which involved activity versus inactivity. But this is a battle that many people are seeking to make with stem cells, that the idea that we should have a very narrow view of the Commerce Clause. And they are supported in that the Food, Drug, and Cosmetic Act actually predates the broader vision of the Commerce Clause. So probably more than you want to know, but realize that this is something legally that is so complicated and ties in many, many, many other pieces. So this case, they have argued that they are not a product subject to regulation, that at most they are saying they should be subject to minimally manipulated regulations. They lost in the D.C. District Court. Oral argument was in the D.C. Circuit just this past October. For regenerative sciences, they drew possibly the worst panel they could draw. One of the judges being the judge who wrote the majority opinion on Bonk and Abigail Alliance. But I think, so my guess is they're going to say FDA does have support for this, but I don't think it's going away. It will start here in Colorado, but it's going to go to Texas. So do not assume when this comes out, do not have parties. We're still going to be fighting over these issues. So I looked at the Commerce Clause piece already. Another crucial piece is this autologous cells. Are they different? We have this just as a substantive point. Are autologous cells different? They may also be different in the context of the law, because since the Public Health Service Act involves contagion and infection, the argument is that no, autologous cells don't involve that, and so you shouldn't have that in play. The difficulty with that is they're even using doxycycline, so they're clearly worried about some sorts of infection going on. So I'm not sure how well that will play. Then a very prominent argument is the practice of medicine. And we can call these products all we like, but you also have to think about the fact that there is a substantial group that says, no, this is actually a product that is really just part of the practice of medicine and should be unregulated. I got a motor here. This is actually the most important slide, and I'm actually going to leave it for discussion. But what I think we're going to do is, if you look at the polarized piece we have here, we have got to help FDA figure out a middle road. My warning on this, and this I actually was teed up on in the discussions of vitamins, I worry that we're going to be where we were with the Dietary Supplement Act, where you actually run into a situation where the political pushback is so bad that you actually end up with worse regulation than you could possibly imagine. So I think there needs to be a lot of discussion of how to make this work. Advertising, we let the genie out of the bag, bottle, sorry, I'm mixing my metaphors, a long time ago with DTC advertising generally. It's a lot more complex, obviously, with clinics. This has joint jurisdiction between FDA and FTC, and of course it's not simple either. Two fronts. One is those two agencies don't always act together. Other front is this ties into another legal fault line, which is the First Amendment. Typically, what the FDA will get from the courts is, no, you can't ban this kind of advertising, you just have to put disclosures, and we can have a long discussion of how well disclosures work. State law also plays a role in advertising, but it's not going to give that much support here. State regulation could play a very important role, but here it's fractured. You may remember in the materials there's a Nature article about Texas, where you actually have Rick Perry promoting the so-called adult stem cell market in Texas, is going to be the place where it's all at. And the Texas Medical Board in 2012 established this, where it said doctors could perform stem cell procedures as long as they're done for research under IRB approval. We can talk about this in discussion too. I think they don't fully understand what IRBs do or how IRB's skill set works within this. And then other states like California have a lot of regulation, but not necessarily in this area. So I'm running out. Role of advisory guidelines can play a very important role on standards of care, but usually not until someone's died. That would be part of a tort action. So it's not terribly effective regulation. And the final piece is on reimbursement. More important, frankly, in Europe than here. But I think reimbursement is going to play an imperfect role on regulation, but one that we should look at as we go forward.
Thank you very much. Let's go right next to Dr. Bianca from the University of Rome, talking about the regulatory and legal frameworks in Italy.